name's Iain Rutherford, and I regularly advise and assist clients in relation to expert determination. Expert determination is a form of dispute resolution where, rather than going to court to resolve the dispute, an industry expert is appointed, and that industry expert will use their own know-how in order to assist parties in resolving the dispute, so they won't be reliant or dependent on purely the evidence or the submissions of one party. Expert determination is generally used for particular technical disputes. For example, where you will commonly see it in IT outsourcing contracts, with an expert appointed to try and resolve a dispute about whether or not a particular contractual deliverable has been delivered in a manner that's compliant with the contract. Or also commonly in relation to financial disputes, say for example the value of a shareholding, an expert accountant might be appointed to determine the value of that shareholding for buyout purposes. Parties will generally agree to expert determination through putting provisions into a contract, and that expert determination will tend to deal with either the entire dispute or a particular technical or financial aspect of that dispute. But parties are obviously free to agree to expert determination in relation to just a typical dispute, or also the court can appoint an expert in order to resolve a dispute if appropriate. One of the key things that should be included in a contract if parties are looking to resolve a dispute through expert determination is that the contract should be clear that the expert is appointed as an expert and not as an arbitrator. We were involved in the leading Scottish case on this, McDonald Estates against NCP, and we successfully argued that an expert was an expert and not an arbitrator. And the consequence of that was that the dispute was resolved in a matter of weeks, rather than, if the expert had been deemed to be an arbitrator, it could have taken months, if not years, to resolve the dispute, which should have very significant consequences for the client. The first reason for using expert determination is speed. An expert determination is typically resolved within a matter of weeks, 2 or 3 months at most. Clearly a knock-on consequence of that is that the cost involved in dealing with an expert determination is much less than a typical litigation. In addition, I would say confidentiality is a significant factor. Expert determination is an entirely private process. In fact, there will be no published decision, and in fact, in some cases, there will be no reasons given for the decision at all. Choice is also a factor. In a typical court action, parties will have no influence over who the judge might be resolving that dispute, whereas in relation to expert determination, then parties can choose who their expert might be, assuming they can agree. If they can't agree, the contract will generally provide that a particular industry body should appoint an expert. But in that case, it's very important to speak with that body in advance of putting a provision like that into the contract to check that they can actually appoint an appropriate expert to resolve the dispute. Possibly one of the major reasons for choosing expert determination, I would say, is finality. Generally, an expert determination has very limited rights of appeal, limited generally to something like bias, for example, which is very difficult to prove. And that's fine until you get to the point that you don't like the determination that the expert has arrived at, because to all intents and purposes, once an expert has determined a dispute, you are generally stuck with that expert's decision. The key benefits for using Brodies is that you're able to draw on a real pool of expertise in relation to all of the dispute resolution options available to you. In a number of cases, it may be that a one-size-fits-all approach in relation to dispute resolution doesn't work, and some form of hybrid is appropriate, with expert determination dealing with some aspects, arbitration dealing with some aspects, some element of mediation as well. Within Brodies, if we're instructed to draft your contract, we can give you full, frank advice about exactly what form of dispute resolution is appropriate for you, so the provisions in your contract will be appropriate, and then if the worst happens and there is a dispute, we have a significant pool of expertise to take you through that whole process and ensure that you achieve the right result for you.